But assuming that the MMDR occupies every possible field of mines and mineral development, does that impose a limitation on the taxation of mineral rights? That's the question you have to answer.
Does that impose a limitation on the taxing power?
Right.
Taxing power. That is the question.
Right.
That is the question.
Which are those provisions? Just tell us.
Well, not the provision. I'll tell you, Lordships. What MMDR does, your Lordships have seen the preamble and other things.
Right.
Statement of objects, etc., etc. There are 2 or 3 very important features of the MMDR.
Yes.
All possible conceivable rights, reconnaissance, mining, and other connected obligations and rights, they're all taken care of in MMDR. Connected to that as an intrinsic measure to the development and regulation, MMDR provides for various financial obligations which are in the nature of imposts. I will not use the expression tax for the time being, but they are imposts. Whatever meaning we may give to impost, that is defined in 366, let us confine to that meaning. So different types of financial obligations are being created by MMDR. Not only created, my lord, along with the limitations inbuilt into each one of them. So the moment that limitation on the financial obligations gets created by MMDR specifically, then those limitations cannot be breached. Then that is what is the occupying of the entire field. That entire field is getting occupied by reason of making the provisions for mines and minerals, in all their aspects, along with what are the financial outgoes which are.
But there's a fallacy. The field of taxes on mineral development, that cannot be occupied because it's a field exclusively assigned to the state.
That is why
occupied field can arise where an entry in the state list is subject to an entry in the union list. Union occupies the entire situation. Alternately, it can occur within the concurrent list. Now, in this case, the entire field of taxation of mineral rights is assigned to the states. Therefore, it can be only by virtue of a limitation under the Central Act that the states are precluded from exercising the right to tax the mineral development. Now, where is that limitation?
That is what I was coming to, Madam.
How do you trace it? Occupied field will not help you.
Madam, that is what I was coming to.
Because the field is exclusively assigned to the state subject to limitations.
So Madam, that subject to, we cannot bifurcate.
Right.
That subject to is a part of the entry. That subject to is inbuilt as a limitation.
You show us which are those limitations which have been imposed under the MMDR Act, which affects the taxing power of the state.
Kindly allow me to place only the relevant sections.
Just tell us, you can enumerate and tell us what those sections are.
I'll enumerate in this way. Let us start with royalty. Going to other sections also, I'll just give the section numbers.
Yeah.
Well, royalty, the rates are fixed. They are on all India basis to maintain the uniformity by reason of the national importance of minerals. Not only the fixation of the rates, are coupled with the right given to the Parliament under subsection 3 of 9 to amend or enhance once in 3 years. So even if the Parliament itself desires, that revisional process or exercise cannot be done in violation of subsection 3.
Right.
So the totality of the rights, totality of the outgoes, totality of the imposts that can be levied in respect of that particular exercise that is inbuilt in the section. Now, if on that, what is royalty? My lords have been discussing it for last few weeks. One thing cannot be denied, whether we call it a tax, whether ultimately what your lordships holds. Definitely, a right in that mineral, which is taken away after extraction, that is parted with. That mineral is gone. And that is why it is on per metric ton basis or ad valorem basis, depending upon how much do you take and extract and dispatch or you consume. Now, kindly note one important aspect. In any of the three lists, the state has not been given, or let us say there is no entry providing for taxes on minerals. List 1, list 2, list 3. There is no entry called taxes on minerals. That has been gone into in India Cement also. It has been specifically noted. So the only entry on which state can fall is 50, taxes on mineral rights. Now, if that right gets eclipsed by reason of the limitations imposed by Parliament by a law relating to mineral development, and that is MMDR, then so long as that limitation continues, that eclipse continues.
Which are those restrictions?
Agaria, you have 5 minutes to go for your 20 minutes to end. Please tell us which are those restrictions?
Very
Which are those limitations
Very
under the
well.
MMDR?
Can you just make a note of the sections?
No restriction.
Is it a tax on minerals under the MMDR Act?
My lord, royalty is a tax or not a tax. That is a separate issue. Now, royalty is definitely calculated if your lordship sees the sections.
What is your submission on royalty?
But if your lordship sees section 9, on what basis it is being payable? Just allow me to place section 9 only.
Just formulate it. Formulate it. We have seen it now many times. Just formulate it.
The holder of a mining lease.
No, what is your submission? Don't read it. Just formulate it.
This 2 lines reading is important. I will not read anything further. The holder of a mining lease granted before the commencement of this act shall, notwithstanding anything contained in the instrument of lease or any law in force at the commencement, etc., pay royalty in respect of any mineral removed or consumed by him. So the conditions precedent are, he must be a holder of the lease. Now, by reason of holding of the lease, we acquired the mining right or the mineral right. And then the calculation that is getting quantified based on how much is extracted and dispatched. So whatever way ultimately your lordships may decide, whether it is a tax on mineral right or a tax on mineral, state cannot get the jurisdiction.
But is it a tax at all?
Doesn't matter. Let us call it impost. Let us call it a levy. That field by reason of this levy, that is getting occupied. Irrespective of it's being called a tax on mineral or not. Because even if it is a tax on mineral,
Field of royalty is occupied. You're right.
well, a tax field of that financial imposition, that financial impost on exercise of that right, that is getting occupied. And well, if you see the entirety of the act, as the learned solicitor was pleased to place before my lords, every aspect prospecting, reconnaissance, mining.
All right, anything else, Mr.
Yes,
Bagarian?
just within 5 minutes I'll complete.
3 minutes left. We'll be
Very
we will
well,
down to
very
the
well,
finish now.
very well. Kindly take the sections. Sections are, my lord, 8, 8A,
Section 8?
8, then 8A,
Yes,
9,
yes.
9A, 9B, 9C, 11D, 13, 18, 25. These all relate to different types of financial obligations and financial matters, financial outgoes.
So according to the field of royalties occupied, including all financial imposts on the exercise of these rights.
My lord, not only royalty,
That's why I said including.
everything connected to mines and mineral obligations. I mean,
All financial imposts.
all financial obligations.
All right,
And
thank you,
they are
Mr.
getting
Bagarian.
occupied as an intrinsic part of development and regulation.
Thank you. Thank you.
But only one section,
Yes.
we have also a note, section 28.
Yes,
Even the notification by which the rates are changed, that 3 yearly, that is required to be placed before the parliament with approval depending upon.
thank
etc.,
you.
etc.
Yes, Mr. Datta, thank you.
My lord, can we make a note of, other day Lordship asked, how can a form, that is form K, in which the lease deed is given, that have any bearing? My lord, this form K is a statutory form under the section. Kindly only make a note of those sections.
That's okay. It was statutory form. No
See,
difference.
statutory forms.
Absolutely.
So there is a
We got the
there are
point.
judgments.
Yes, Mr. Datta. Thank you, Mr. Bagarian. Yes, Mr.
Kambata will
Datta.
take 10 minutes. You wanted to finish first.
Who?
Mr. Kambata.
Mr. Kambata.
May I be, Lord,
Would you Lordship give me 1 more minute only?
No, Mr. Datta. Thank you.
My lord, 1 more minute only for mentioning the name of an act. Only for mentioning the name of the act.
What is the
The
act?
other day Lordship asked the question, is there any other law under 54 relating to mineral development? There are 2 other laws relating to coal. One is Coal Mines Conservation and Development Act 1974. That is at page 1873 of volume 4.
We'll look at it. Yes, Mr. Kambata.
Lord, I'm grateful to your Lordship for giving me this opportunity of addressing virtually. I'm sorry, my Lord, for personal reasons, I couldn't be here physically before your Lordship. So, my Lord, I'll restrict myself. I have 10 minutes and I've heard the argument, my Lord. I know what apprehensions are troubling my Lords, and I seek to address those. Lord, I want to make 5 points on entry 50. As we have seen, entry 50 permits the states to tax mineral rights, but it is subject to any limitations imposed by Parliament by law. The first submission, therefore, is that the states do not have exclusive competence to tax even mineral rights. I'm not getting into the issue of whether mineral rights is narrower than minerals, but that has been dealt with. But whatever the subject matter is, the states do not have exclusive competence. It's always subject to Parliament. I say this because if my Lords see my written submissions in volume 2G, pages 2 to 17, I have extracted a portion from the case in HS Dhillon, which enunciated the test thus. It said any tax, any matter, including tax, which has not been allotted exclusively to the state legislatures, will fall into the province of Parliament. Because as we know, Parliament has the residuary power to tax under Article 248(2) and read with entry 97. So unless it is allotted exclusively to the state, it would always fall within Parliament's power. That's point number 1. My submission is...
Mr. Kambata.
Yes, madam.
Allotted exclusively to the state legislatures is not inconsistent with limitations on the exercise of the power.
That is right. That is right. I accept that. I accept that. I accept that.
Therefore, the field is not given to Parliament. The field is exclusively assigned to the states, but it is limited by a law which is passed by Parliament in the interests of mineral development.
Lordship, please. Maybe take that, my Lord, as the first. I accept that, my Lord. I'm not saying that Parliament can step in without imposing those limitations by a law relating to mineral development. The second point, therefore, is linked exactly to that. That law pertaining to mineral development is empowered by entry 54. And as the paragraph in synthetics and chemicals that Dr. Singhvi referred to, paragraph 40, I won't read it again, it says entry 50 is the one exception to the rule that a power to tax cannot come from a general entry. It says the power can come from entry 54. That's what 7 judges of your lordships held in synthetics and chemicals. More importantly, and I rely on Sirvai, a passage from Sirvai as well as in Hindstone of your lordships, the judgment, the power to regulate will include the power to prohibit absolutely. And if my lords would kindly see my written submissions for one moment, at page 7 of those, para 18, I've set out the passage from Sirvai, which might be of some assistance. Page 7 of the written submissions, para 18.
Just 1 second.
It's volume 2G.
Oh, 2G, volume 2G, page 2, it starts, and at page 7. My lords have that?
Yes.
May I just read that? A tax on mineral rights is made expressly subject to any limitation by Parliament by law relating to mineral development. Consequently, Parliament would have the power to regulate or prohibit the levy of a tax on mineral rights if such levy obstructed or hampered mineral development. And even generally, as I said in the judgment of Hindstone, 1981 to SCC 205, your lordships have taken the view power to regulate includes power to prohibit. Now, if the limitation imposed in entry 50 prohibits, then as felt from the Honorable Chief Justice this morning, there would be a vacuum, because then nobody would be able to tax mineral rights, which can never be, because the residuary power to tax is always with Parliament. And therefore, if the limitation effectively prohibits, then in my respectful submission, Parliament would have competence not only under entry 54, but also read with its residuary powers under 97 and 248. And the third point is, of course, the very language of entry 50 by law relating to mineral development imports the fact that in this law, limitations at least can be put on the taxing power. Therefore, they can be related to the field of taxation. Your lordships have held in state of Karnataka and Meghalaya also that the word subject to take the entry completely out of the scope of powers of the states. The word subject to an entry 50. I'll show that later if I have the time. The fourth point, and this is, I think, my main point, and others have made it, but I just want to substantiate it. Entry 54 envisaged a complete code on the law relating to mines and mineral developments. And this would include taxation because of the language we find in entry 50. We've seen the sections, they've been shown to my lords by the learned solicitor. They are extensive, they purport to cover the full range of matters as was held in Tulloch's case at para 12 and 14. But specifically, there is a section 25, which we saw this morning, which permits the government to recover any areas of rent, royalty, tax, fee, or otherwise. Expressly uses the word tax, which means the scheme and scope of the act is expressly, it covers tax as well and a recovery of tax. And Dr. Singhvi has already pointed out why royalty is a statutory impost. Dead rent under 9A would be clearly a tax. And even 9B and C are cesses computed on the basis of royalty, which are in the nature of taxation on impost. Now, the legal consequence of a complete code, as your lordships are familiar with, I have set out at paras 30 to 35 of my note. My lords would kindly quickly go to page 11 Your Lordship's judgment in the arbitration and stamp pack matter. I've set out the passage at page 11, relying on the genesis of an idea from Justice Tulsapurkar sitting in the Bombay High Court, that if an act is intended to be an exhaustive or complete code, it impliedly excludes all other laws. So a complete code on mines and minerals which includes the power of taxation, will exclude the state's power. And I've set out a passage from Sirvai. If my Lord will just see that at page 11, para 31 of my note, he actually refers to what the consequence of the MMDR Act is, was entry 50. He says, and I quote in para 31, in the first of these cases, relying on a judgment of the Mysore Act, it was also held that the state legislatures lost their power to legislate under entry 50 list 2, and the provisions of the Central Act of 1957, and particularly section 25 of that act, supported this conclusion. That's the fourth point. The fifth point is that under our constitutional scheme, limitations include implied limitations. They are not limited to express limitations. And if my Lords would just kindly see para 11 of my note, page 5, I have extracted some portions from Kesavananda, which explain that everything is not said expressly in our constitution. Limitations can be implied and must be implied. And they can be implied either by necessity or from the scheme of the constitution. If my Lord would just see para 11, page 5. Just the first two extracts, I'll just read. From Justice Sikri's judgment, para 210, I come to the same conclusion by another line of reasoning. In a written constitution, it is rarely that everything is said expressly. Powers and limitations are implied from necessity or the scheme of the constitution. And the next two extracts also speak of, if you imply that, then it acts as a corresponding limitation on the states, the power of the states or provincial legislatures. So for the very structure and construct of entry 50 read with 54 shows that the intention was to place this entire scheme, including taxation, because one can't delink taxation from mineral development. If a state heavily taxes mineral rights, it might thwart or retard mineral development in that state. The whole idea was to unify it. Now I have 3 points on unification. The first is, and I've said this out, since my time is limited, I want to just point out at page 13 of my submissions, I've referred to the 1948 MMDR Act. Because there was an act before this one in 1948, which expressly contemplated taxation. And one must remember this was made by the Dominion legislature, which was effectively the same as the Constituent Assembly at that stage in 1948. So they expressly permitted taxation as part of the MMDR Act 1940. That's point number 1. Point number 2 is, let's go back to the Government of India Act, because now may I request my Lords to see para 44 of my note, because for convenience I've set out the respective entries. This is very illuminating. The entries are almost identical. And if my Lords see para 44, page 14, entry 36 is the equivalent of entry 54, entry 23 is 23, and 44 is the current entry 50. Now, there are debates of the House of Commons. I agree that they're not authorities to be cited, but it's illuminating to see those debates. And if my Lords would just see, I've extracted them for convenience in the annexure to my submissions at page 18. I would have shown them at length, but there's no time. So volume 4, they are contained in volume 4M from pages 54 to 58. And the anxiety of members there was to put to the then Solicitor General in England that should not there be a complete code, and should not all powers, including power to tax mineral rights, be vested in the federal legislature, and on provisions near identical to ours.
But you had mentioned the 1948 Act.
Yes, madam.
And you said that the expression taxation was specifically used therein.
Yes, madam.
Now, we haven't gone so much into detail, but you see, in the 1957 Act,
Yes, madam.
the taxation thing has come only in the recovery section. What was the difficulty for the 1957 Act to also specifically say taxation? And that would make our task a little simpler, instead of
I understand.
say that royalties and exaction and go back to the definition of taxation.
Even in the 1948
Answered
Act,
in the 57 Act.
Correct.
Although you may be right there that, the union government has the power to exclusively sort of pass laws on the subject, but has it denuded to the extent of taking away the right of the state to also impose taxation on under entry?
my lord is right, my lord. We are before your lordships because there's not such an express reference. But reading the scheme of the Act, for example, in the 1948, the reference is in the rule-making power. The power to make rules for levy and collection of royalties, fees, or taxes. I've said that out in my para 41. All this is internal evidence to show that the range of the Act intended and did cover taxation as well, in whatever name called. Because if you pluck out taxation and give it to different states, there will be a regime which will be inconsistent all over the country. That was not the parliamentary intent. And that the debates which I've set out in Annexure A, I've extracted some of the questions and
Mr. Khambata will have a look at it. Thank you. Thank you, Mr. Khambata.
I leave that thought with your lordships that the whole intent will be subverted if implied limitations are not read into the power under entry 50. That's the crux of it.
Thank you. Yes, Mr. Datta.
Maybe,
Thank you,
Lord,
Mr.
my lord,
Khambata.
I made a PowerPoint presentation, but before Mr. Dharaj Khambata concluded, there is a very important passage in the Joint Committee in 1933-34, which prepared the Government of India Act. And I'll just flag that the original entry 23 of List 2 said that tax on mineral rights, they were no subject to limitation. And there was a general power given to the federal government. A member of the committee called Lord Percy, he flags the issue and says, if you give complete general power to the federal government and unlimited taxing power to the provinces, then the very regulatory power of the federal government will be in jeopardy. That is why then they put subject to mineral rights. I'll give that passage from Lord Percy, and the Solicitor General agrees. Yes, this is a very valid point, because unlimited taxing power can completely jeopardize the regulatory power of the federal government. Now, my lord, I'll come to my submission straight away. My lord, first of all, the taxing powers of the state. There are normal allocation of taxing powers. There are 12 taxing powers given to the union, entry 82 to 96, 92B, and 16 subject matters given to the state government. That is 46 to 62. It's now one less because entry tax is gone, octroi is gone.
And to the union, which was one?
Union 12 subject matters, and to the state 16, now 50,
82
to 92B.
Yes.
And for the state governments, entry 46 to 62. Of course, now 55 is deleted after GST. But out of these 15 taxing powers,
54 is deleted.
sorry, my lord,
So 54 is deleted.
55 is deleted.
55.
Entry tax.
Oh, 95. Yes, 55.
Because now it's one nation, one tax, so there's no
Right.
check post and all that. Now, my lord, out of these entries in the state list, 3 entries use the word subject to. Entry 54, the power to levy sales tax, is subject to 92A of list 1. Lord, I'll give a complete note, my lord, to save time. Entry 54 is subject to entry 92 of list 1, interstate sales. Entry 50 is subject to a law made by Parliament. And entry 57, motor vehicles, is subject to principles in entry 55 of list 3. So 3 taxing entries are subject to something. Now, the word subject to has been subject to a lot of interpretation, and a recent judgment by my Lord Justice Gawai and Justice Nagaratna in the case of Baharul Islam, Lordship will just make a note, 2023 SCC online. Page 79, 2023 SCC online, page 79. Para numbers 85 is the most important. Subject to means yields to. So a taxing power which uses the word subject to X must yield to X. Now take 50, my lord. I'll not get into entry 54. If I have time, I'll mention that. So 50 says subject to a law made by Parliament. So my submission is this taxing power is still a state power. There's no question about it. Because all the money goes to the state. All the money goes to the state. But it is subject to a law made by Parliament, meaning the taxing power of the state must yield to parliamentary legislation. And what has parliamentary legislation done, my lord? My lord, I am taking the plea in my slide number 2. My lord, I took the liberty of making a PowerPoint so it will save time. Lordship just sees slide number 2. I'm just going to refer to slide 2 and show this.
Page number?
Slide number 2, my lord.
Where do we get that?
I've made a PowerPoint presentation. I got hard copies if your lordship wants to save time. Lordship may just take the hard copy. I just got 10 minutes.
No, just one second. But written submissions volume?
No, I gave, Lord, what happened? I gave a written submissions earlier.
PowerPoint.
In written volume 2 it is there. Volume 2 what page?
The PowerPoint is there?
Folder volume 2. There's a separate file.
Well, can you just take a hard copy, my lord? I've got 10 minutes.
Quality presentation is there.
Yes.
Very much there.
What page number, my lord? Your lordship has got slide 2, my lord. I'll just give a hard copy in case your lordships are finding it. Yes. Now, please come to slide 2. Now, I'm submitting what Parliament has done. Slide 2, your lordship comes to limitations on taxing power. My lord. My lord, my submission is, all your lordships have got it, my lord? All my lords have got it. List. Yeah. My lord, can I pass on a hard copy in case
It's there in written.
Yes. Now, my lord, I am submitting that when you say taxes on mineral rights, when a legislature has the competence to make a law relating to tax, it basically can decide on 3 components: the levy of tax, the assessment of tax, and the collection of tax. My humble submission is, what Parliament has done is, it has divided minerals into 2 parts: major minerals and minor minerals. On minor minerals under 15, state can levy tax. In Tamil Nadu, they call royalty on major minerals. They call it seigniorage on minor minerals. But both are basically taxes or imposts. Now my submission is, why did Parliament do this? Parliament did it, in my humble submission, to impose financial guardrails or financial limitations in national interest. And I'll draw parallel to sales tax. So the first submission is, Parliament has imposed limitations on major minerals. They have set out in second schedule what are the major minerals. They have specified how much you can tax, either so many rupees per ton or 5% ad valorem, 20% ad valorem. And then, my lord, allocation of taxing power, taxing revenues. Insofar as 9 is concerned, Parliament says entire thing goes to consolidated fund of state. Come to 9B. 9B, District Mineral Board, it says it will go to the district, doesn't go to the state. It goes to a trust to be used for the purpose of the district. So what Parliament has done is, this is how the taxing powers has been regulated by Parliament. So they make a law which imposes the levy, but the entire funds go to the state. And this is what I've said. Now, my lord, kindly come to slide 4. Please come to slide 4. I have drawn a map of Tamil Nadu. Lordship has got the map of Tamil Nadu.
Yes.
My lord, what I've done is, what is the Lordship kept asking the question, what is the interplay of 49(2) with entry 52? Now, I'm just making a suggestion for Lordship's kind consideration. Now, tax on land and buildings, land will be a genus and mineral lands will be a species, because not the entire state may not be a mineral. So what I'm submitting is, under the Mining Mineral Development Regulation Act, you have reconnaissance permit, you have this permit, and ultimately a mining lease is given for a period area not exceeding 10 square kilometers. It can be extended depending. So some mines can be 30 kilometers, 40 kilometers, etc. Now I'm just suggesting to your lordship that whatever is the black dot represents the area for which a mining lease has been allotted. And who gives the mining lease? The state government with the approval of central government. You make an application to the state. And so my humble submission for lordship's consideration is, the black dot area is the entry 50 tax. Rest of the state is the 49 tax. And on the black dot area, They cannot be both a 49 tax and a 50 tax. That's the submission. Now, my lord, third point on why royalty is a tax. My lord, I am very clear, royalty is a tax. You can call it impost. That's not quibble on words. It is a tax, it's an impost. And why do I say it's a tax? On India Cements, where Lordship sees, the opening page of India Cements is page 1155. And at 1156, my lord, Justice Nagaratna asked the question, what is this royalty? The opening paragraph of Justice Mukherjee's judgment says, India Cements is paying royalty at page 1156 under the Mineral Concession Rules 1960, which is under the 57 Act. And please see, what do they say? Royalty, limestone, government land, 75 per ton, subject to rebate. The schedule. Now, my submission is, what are the indicia for a tax? Typically speaking, because if you apply the Bambach test, royalty is not a tax. Then what is it? Is it consideration? Is it rent? It fails because the indicia for a tax is, it is normally given at a particular rate. The word rebate, ad valorem, schedule, alteration, all these are factors which are very, very unique to a tax. Consideration under 2D contract is nomen juris. It relates to a contractual relationship. In DK Trivedi, Justice Madan said a mining lease is not an ordinary contract. So my humble submission is royalty is a tax. That's the first submission. Secondly, the district mineral board is a percentage of the royalty. That is also a tax. And finally, my lord, I'll say why India Cements was wrong. Oh, sorry, why Kesaram was wrong. India Cements, what happened was, the royalty was under these mineral concession rules. Parliamentary levy, parliamentary rules. The Tamil Nadu government under section 115 and 116 of the Panchayats Act said the cess will be at 45% of the royalty. They said 45% of public revenue, and then they amended the explanation and said land revenue in public revenue includes royalty. Now, Kesaram says cess on royalty is a tax, but royalty is not a tax. In my humble submission, it's a logical fallacy because 99.99% of the cases in tax law, everybody who practices tax knows, cesses and surcharges are piggyback levies. They're always related to a mother levy. Education cess 12.32% of the service tax. Higher education cess 0.6% of income tax. So if the cess on service tax is a tax, then it's paradoxical to say that the mother levy is not a tax. And that's exactly what Kesaram does. They say, no, royalty is a tax is a typo, but cess on royalty is a tax. Now, if cess on royalty is a tax, by logic, my lord, the royalty has to be a tax. I'm putting the inverted paradox. And finally, my submission is royalty is also tax because it satisfies all the four tests of Govindram Gangasaran. Your lordship sees, I've given in the last slide. What are the four attributes of tax? I've given in slide number 8. Taxable event, person liable, rate of tax, value or measure. All these things are satisfied. And finally, not just 1 minute to say how Parliament subjects it to levy. Take sales tax, not just one, I'll conclude. Entry 54, till this Bengal immunity, lordship knows the full confusion in Bengal immunity, which state can levy tax, United Motors and Bengal immunity. Ultimately, the validation was upheld in MPV Sundaramaiah. After the 6th Amendment, they introduced 92A and said, what was an absolute power of the state was taken away and made subject to 92A. So what happens in 92A? Central sales tax. Central sales tax puts two limitations. It under section 14 makes declared goods, which include many of the minerals also. Otherwise, each state can levy whatever it wants.
Thank you, Mr. Datta.
I think I'm less than 10 minutes. Not any. Yes.
See, not only you, others have also argued this.
Hmm.
Money going back or the entire money is usurped by the state. Should that be the logic for?
Yes, I'm very grateful. My Lord Chief Justice also raised the point. You keep saying it's a tax on, it's a state tax. Just think for a moment. Just suppose Parliament tomorrow says, I will make the law and I will keep the entire money with me. That could be a serious challenge because you can't make it a state levy and the entire funds goes to the Consolidated Fund of India. Because the point is, why I'm saying
that is simple enough.
Huh.
But if we understand that state has a power to tax,
Yes.
and if center says that no, I will impose the tax,
For major minerals.
but I'm giving you, on mineral
For major
rights,
minerals. Yes,
right.
yes, yes.
But I'm giving you the entire, let us say entire.
Yes.
Does that satisfy what is given to the state under list 2?
Lordship may not just take giving.
Despite the impose.
Yes. Lordship may not just take giving. Entire assessment is by the state. Collection is by the state. Special courts are set up by the states. All the Parliament is doing is don't go haywire in a levy. Suppose they leave it to the state government. Then any state government can levy any tax. So what I'm submitting is the very fact that the entire money goes to the state itself shows that the state is not denuded of their taxing rights, taxing money. All happens, the ceiling limit is imposed. Like in sales tax, once you're a declared goods, you can't put more than 5%. Sorry.
56 interstate trade is
Exactly.
only by the central government.
Pardon me?
It's only by the parliament.
Yes.
Under
Again, what happens is
The power under Article 286
yes,
with regard to
interstate sales.
only the parliament.
Only when Parliament can levy.
Only the machinery is by the state.
Yes. Why I gave the analogy?
From the power to impose a tax.
No, why I gave the analogy is after 6 years of independence, the state's absolute power became subject to limitations. Now, limitations can be in any way Parliament wants. In sales tax, what did they did? They said not more than 5%, only single point levy. For minerals, they said major minerals you can tax in the second schedule at these rates. So now suppose it is 8% ad valorem, it's an all India tax. Whether you find the coal in Bihar or you find the coal in Karnataka, it's an 8% tax.
So feeling the heat from behind.
Very much, my lord. Unfortunately, I can't be pushed in front.
Thank you, Mr. Datta. Now, Mr. Datta, you have to tell us who is following now next.
Mr. Ghosh is following. I mean, he wants to take 1 minute to.
Just a minute, I'll take. I'm going next subject to what.
No.
90110.
Bro, the de-tagging I'll give the note tomorrow in my matter.
90110. I have only 3 points to make and I will not take more than 10 minutes. 3 issues have been troubling this honorable court. First, is there a possibility of a sovereign right of taxation to be ever denuded? That's the first thing. Whether the sovereign right of tax of a state can ever be denuded. That's the first question that has been troubling my lords. The second, has such a denudation ever happened under the current context? And third, whether the parliament can arrogate that right of taxation under 1897. These are the 3 very particular things, my lord. Insofar as the first issue is concerned, my lord, I'd like to place a judgment of the US Supreme Court, where the issue was of mineral right taxation exercised by the tribes, the Apache tribes. The Apache tribes, under their formulation, Lord, this judgment I had given it to the court master. This submission, this particular point is not there, this judgment, because I also fine-tuned my judgment based on the 455 US 130. 455 US 130 Marion. The opinion of the court was rendered by. It's not there, but I've just. It has been given to the court master.
Marian, yes, we got it.
Yes, my lord. This was the case where, and I'll just briefly explain what had happened. The tribes, the Apache tribes were sovereign.
Yes.
They had the power to legislate and also impose tax. On minerals, they imposed a tax called severance tax. On non-tribe, non-Indians, so to say, and non-Indians challenged it. Issue that came before the US Supreme Court and the opinion of the court was by Justice Thurgood Marshall was sovereign's right of taxation cannot be denuded. However, the very wordings of the constitution of the tribe said, and I'll read that particular thing, Malad text, internal page 134. At the bottom, I'll just read the charter. Yes, please, yes. The bottom paragraph. This was the charter of the constitution. Inherent powers of the so-and-so tribe, including those conferred under section 16 of the Act of June, as amended, shall vest with the tribal council and shall be exercised thereby, subject only to limitations imposed by the Constitution of the US, applicable federal statutes, and regulation of the Department of Interior, and restrictions are established by this revised constitution. Very similar in construct, that your power of taxation can be limited by the US Constitution or the federal government. In this case, the same thing is happening as well. In that context, my lord, three things the majority opinion said. This power can be used to restrain the tribes, and I'll take, my lord, where it is, to abridge that right, and also to take away their right. All the things are possible. I'll take, my lord, kindly have page 141, internal page 141. Of course, second paragraph. Of course, the tribe's authority to tax non-members is subject to constraints not imposed on other government entities. The federal government can take away this power, and the tribe must obtain the approval of the secretary before any tax on non-members can take effect. These additional constraints minimize potential concerns that Indian tribes will exercise the power to tax in an unfair or unprincipled manner, and to ensure that any exercise of tribal power of tax will be inconsistent.
What is the next point?
Yes, Lord, that is one. So therefore, that is possible. Now, the second point is, if it is possible, then has it happened? Because the words used in entry 50 is that any limitation, and my lords have read the word any in the bearer bonds, in the electoral bonds case to means some, one, or all limitations. And therefore, it could go to anything, and reasonable restriction also has been meant to be complete prohibition. It is our submission, my lord, that section 9 of the MMRD and the architecture of MMRD has actually imposed an entire restriction on the taxing power of the state qua mineral rights. We apply the aspect theory. There is one aspect that has been written there, which is the taxes on mineral rights. There could be other aspects, we don't know. Subject to the states having that power on that aspect, state can levy tax. But the aspect of tax on mineral rights has been taken over by the parliament by virtue of section 9, because section 9 has all the ingredients of a levy, of a valid levy as per Gangasaran and Govindsaran. The taxable person is there, mineral right holder. Taxable event is there, the conferment of the right and extraction of the mineral. The measure and value of taxes, the rate of tax is there in as much as there is a rate, specific rate that is provided. So section 9 is the only sphere qua mineral rights, because there is nothing left thereafter. Maybe there is other aspect of mineral rights that may be there, but that the state will have to find power, unlike the parliament, which has a residual power. And the third is whether the parliament can arrogate itself the power to taxation. Well, the submission is as follows. We apply the principle as applicable in doctrine of eclipse. My Lord knows, if a pre-constitutional law was ultra vires the fundamental right, it is not dead and gone. It is in a moribund state, which means it is inoperative. Applying the same principle, as soon as the parliament exercises the power under entry 50, that whole taxing power is in a moribund state. It is inoperative. The purpose of 248 is to deal with such subjects and such enumerations which is active.
It can become inoperative.
Because conferment of power means that you must use that power. If you cannot use the power, it is in a moribund state. It has to that extent become dormant and ineffective. Therefore, that cannot be there.
Thank you, Mr. Ghosh. Thank you.
Obliged.
Now, who's next?
Yes, my lord, as per goes.
Anything over and above what has been argued?
Yes, we have
We'll note your appearance.
sequence. By consensus, sir. So,
Sorry?
sequence, as per sequence. Lord, as per sequence, I am supposed to do. Lord, Let's avoid.
You can.
I'm sorry. Mr. Datar is
Not
witness
like
of
your
that sequence.
SLP day, Monday, Fridays.
I'm,
Somebody
I'm so sorry, my
like
lord.
a T20, yes.
I'm so sorry, my lord. As per sequence, I was supposed to come, my lord. I am,
Kumar.
as per sequence, I'm so sorry, my lord. This has happened at my turn. Lord, I am only answering few questions which have been raised, and as per my submission, my lord, few new answers can be given to that, my lord. One question which has been repeatedly asked by particularly by Justice Nagaratna and Justice Roy, my lord, that to what extent Parliament has taken over, my lord. And to that, my lord, Mr. Salve has referred that trilogy, and my submission is the consistency in all constitution benches except Kesoram is that total inundation in respect of both regulation as
Not
well as
total inundation, total denudation.
denudation, extraction, all denudation also a word has been used in Sandur, my lord. Denudation and Sandur and Bharat coking coal has gone. Bharat, denudation.
Right.
Sorry. Sorry. Bharat coking coal and Sandur has gone to the extent of saying that even executive power
All right.
under
I
Article
think
1.
let's
Lord,
start
when
the other
there's
side at
one more person,
3:30.
Lord.
Give 1 hour.
Lord, when
We've
Mr.
already exceeded
When
it.
Mr. SG was citing that
Thank
form, my
you.
Lord,
We'll-
my Lord was looking
Thank
for
you.
substantive
Thank you,
limitation.
Mr. Kumar.
My Lord,
Just tell us
rule-
who are the others who, please give us your appearances.
Lord, 227(3), my Lord, there is substantive
Yes,
limitation.
yes, Mr. Dwivedi, please start.
9.7. In sequence myself.
Yes, Mr. Vasudev.
Sir. Lordship. New point. New point.
Yes.
New point, sir.
9.7, 1 lakh.
New point.
इसको सुन तो लीजिए।
Lordship, here I
पहले-
raise the point only fifth and
आपने
substance.
पहले
New point.
सुन तो लो जरा।
In sequence, sir, I
आपके
was.
पहले सुन तो लो। इतनी भी तो क्या जल्दी है? आधा घंटा है हम लोगों को। आपके पहले सीनियर काउंसिल है, इनको 2 मिनट दे दीजिए।
That's it.
Just want to point out one fact. I beg to appeal Civil Appeal 945A of 2013. But we learn every day. sir.
Yes, Mr. Vasudev.
I fear for the NTPC. They have given us submissions which are on record for supporting what everybody else says. I just wanted to point out a notification of the 1st of August 2077, issued under 2007, issued by the Government of India, which deals with the question of royalty and the calculation. And in paragraph 4, it says, for states other than West Bengal, levy cess or other taxes specified to coal-bearing lands, the royalty allowed shall be adjusted for the local cesses, because we have a situation where the local cess comes in. So you have a question of a royalty. Now, if the local cess is to be there, then in keeping with the constitutional scheme of having a standard tax or a standard royalty all over the country, the local cess should be included.
Thank you, we got the point.
In
Yes,
that-
Ms. Bhati, thank you.
Just one more second minute. In that context, I must say that in our cases, we are operating in Madhya Pradesh amongst other states as the NTPC, acting in the national interest. We are now being levied with a cess, which is very high, making it difficult to balance the finances with regard to the other states. So my respectful
Thank you.
submission is this notification, cess should be a part of royalty, not excluding them. Of course, we will argue this before the other benches when it comes up. What is the submission to your lordship? Grateful.
To appear for 2 of the coal companies, my lords, my written submissions are already on record. The only additional point that I've made, my lords, which some of the seniors have touched upon, is the Coal Mining Area Acquisition and Development Act, my lords, which is the regime under which we operate. And there, my lords, the levy that is by way of an amendment. The Act is of 1957. The amendment comes in 1971, by virtue of which we are paying something akin to royalty on the same rates to the state governments. So, my lords, we have an alternate submission, but my lords, I wanted to bring that because as nationalized coal companies, we are, my lords, paying that to the state governments under that regime. Just 2 lines, my lords, I want to add, my lords. Firstly, my lords, your lordships are looking at the interpretation of entry 50, which is a taxing right, taxing power, but it is not eclipsed by a taxing power. It is eclipsed by a regulatory power. So my lords consider that aspect. The second thing, my lords, taxing power is limited. but the limitation itself is of very wide amplitude, because the entry reads any limitation subject to it being for mineral development. So the entry is smaller, my lords, and the limitation is wider, is my respectful submission. And though the entry is tax, but your lordships will not find a limitation which is of tax, because the entry does not contemplate a limitation of tax alone. My lords, one more submission, just additional, my lords, it fell from your lordships during the hearings, my lords, with regard to intergenerational equity. I also wanted to place, my lords, the aspect of intergenerational equity in, my lords, harnessing and development of the minerals and their usage in national interest for national infrastructure is an equally important component of intergenerational equity, my lords, that this generation has to bear in mind. I'm very grateful.
Yes, Patil. Yes.
Lordship, can I come to the one question?
Right.
Yes.
Volume 2, page number 64. What is tax is nowhere defined in the Indian Constitution. There are three essential features of the tax in India. First is it can be imposed by the public authority or you can say that is the government. Second, it is the compulsory contribution to the government. Pardon?
Who are you appearing for?
Appearing for the IA number 237364.
Who are you intervening for?
Private party.
Which private party?
Not getting, sir. In Mada versus Sale. IA number 237364.
What does the private party have to do with this litigation?
Yes, sir. These minerals are for the ultimate use and the benefit of the.
Can't continue ad nauseum like this. All kinds of private parties can't come here. It's a dispute between the.
Sir, let me say I have the locus and I can say before you. These minerals are for the ultimate use for every citizen of the India. In watches, in medicines, in everything of daily life, we use these minerals. So when the tax rates or the disputes of the center or the state are deciding that issue, then if the cost is higher, then every citizen will be impacted by this, sir. It is directly connected to every citizen of India.
All right.
Sir,
we are discussing and dilating upon the interpretation of three entries, my lord. Entry 23, entry 50.
That we now heard that for the last 3 weeks. Point.
The point is that the expression common in all the entries is mineral development. My lord, the entry 50, as my learned friend has just said, that is controlled by a general provision. Entry 50 is controlled by a.
Then why are you repeating what Ms. Bhati said? She made a very valid point.
Yes.
Don't dilute the point which Ms. Bhati made.
Entry 50, my lord. In Tolok,
Thank you. Yes.
In Tolok, your lordship has held that the entry 23 has been carved out in view of entry 54 of list 1. So therefore, the entirety of, as if it does not exist. That is why
it's not carved out. It is subject to.
It is a subject to means that the area of entry 23 has been carved out from entry 54.
No. Please don't say that.
Therefore, my lord, there is no entry 23 existing. That is why the fees, whether it comes under entry 66, was denied. Second is, my lord, in the second point. My lord, I have given a submission, my lord, in which I have pointed out 10 flaws or errors which is committed in Kesharam, my lord. That has to be seen, my lord. I have given my submission.
Thank you. Yes, sir. What do you have to say?
My lords, I have an intervention on behalf of ESL Steel for Vedanta Group, my lords. Lot of submissions have been made on nature of royalty, whether royalty is akin to tax or royalty is a tax. My submission is converse, my lords. I am saying that royalty may or may not be taxed, but it is definitely not a consideration. And the proposition of law that I'm advocating is that any amount that a state or an instrumentality of a state which collects in order to perform a sovereign function or constitutional function or a statutory function, my lords, cannot be towards a consideration, because what the state is doing is not a service, my lords. The consideration presupposes, my lords, whether it is understood under the contract.
So therefore, are you postulating that Vedanta can excavate as many minerals as it wants and you're not bound to pay anything?
My lords, what they're bound to pay may be in the nature of tax, but that's not consideration, my lords. So
you can excavate from the bowel of the earth without having to pay anybody. That's your submission.
not, my lords, the nature of that particular payment may not be treated as consideration because
That means you don't pay any consideration at all. All right, thank you. Who else? Who else?
May I permit it also? Point second. Lordship, here I am discussing about the fifth and substance. Doctrine whether law is valid by examining its dominant. Yeah, chemical engineering versus 9.901.7. Only two things here. One thing is Lordship already pronouncement by the apex court.
So Data,
Later on legislation.
I think we rushed you a bit. Mr. Rakesh Dwivedi can start in the morning tomorrow fresh. Is that okay? We have left for 20 minutes.
Yes, as a lordship.
I think that's better. Mr. Datar, we rushed you a little bit. We'll give you the last word. You can wrap it up for us. One second. Please now, let's not go from the sublime to the ridiculous now, please.
Wait, please, Lord.
Mr. Menon wanted to have 2 minutes.
Yes, certainly, Mr.
Lord, I had occasion to assist its Honorable Court in the larger bench in the Tresiyama Jacob, which everyone was referring to. That is, where in Kerala, the minerals are vested in the private persons. Now, in that one issue was left open was.
Mr. Menon, why don't you do this? Just close everything.
Yes.
And give us your core consciousness. Tell us what you would like us to.
My point was that.
Just leave aside everything and just tell us what you.
Yes. My point is that.
Conceptually in your mind.
Yes, royalty and tax are mutually exclusive. And the royalty is a proprietary right, whereas tax is a sovereign right, prerogative right.
Yes.
Now, when state waste mineral, and as per the water principle, Hasbury's and all these principles followed by the honorable interrogation, etc., it can be possessed separately. Minerals can be possessed separately because it's a subsoil right. Now, when you vest the mineral in the government, then government becomes the proprietor. Now, when you are saying taxation, it's a prerogative right. Can the state impose tax when you yourself is the owner? This, of course, for the timing, probably it appears, in fact, my duty to assist the Honorable Court. Now, when they are collecting royalty, they are the owners. How can they impose the tax?
Permitted by Constitution.
Now, so far as the taxing power is concerned, entry 49 and 50. Yes.
Made the conceptual difference that royalty is something which you charge in exercise of your proprietary right.
Absolutely.
Tax is something which you levy
Correct.
in pursuance of your sovereign power.
Correct.
When the same entity wields two hats, you are both the proprietor of the mineral and yet you are also a sovereign. So imposing both is not inconsistent because you are exercising your right as a proprietor in one instance, as a sovereign in the other.
In fact, one position I agree with, entry 49 and 50. These are to be read together. The entire power is vested with the state. I have no quarrel on that. Because entry 50 is carved out. Otherwise, the entire taxation power is there in entry 49. This is carved out for a limited purpose of bringing in a limitation by the parliament, by the law being passed by the parliament. So that aspect probably I don't think I have anything. But when you are the owner, for example, let us assume that not in the case of a land revenue, and you are making an assessment and you are selling your own property. No. You are the owner. At the same time, you are exercising a prerogative right. Both these things cannot go together. The moment you become the proprietor, then you are not a sovereign, and vice versa. When you become the proprietor, you cease to be the sovereign. So when you are imposing a tax on your own property.
No, but it's not really, because what the state is doing is this. A private party, the lease owner or the leaseholder, has been given the right to extract. That private party extracts the material and removes extracts the mineral and removes the mineral. For that, that person has to pay royalty to the state.
Activity is being charged.
Right. And therefore, when the state now imposes a tax, it's not imposing a tax on itself. It's imposing a tax on a private party on the royalty which is paid by him for the extraction or removal of the material, of the mineral.
Yes. I got what's flowing from your lordship. So that's why, let's just have a look at entry 49 and 50. I'm not going to read out or anything. Entry 49, entry 45 and entry 50. Entry 45 is land revenue. Entry 49 is land and building. And land is a bundle of right as per Hasbury, followed in Karageshwar or DK Trivedi or whatever it is. Now, out of that, you are separating this, as I already pointed out. Now, for that purpose, that power is always there with them. But in this case, by this, because probably I'm arguing against this thing about this thing. I mean, a tax when it is being imposed, it is, when the restrictions are being brought in to the MMDR Act, Section 9, what is being, more stress was given. According to me, it cannot be. Because Section 9 is only a regulation. And Section 9(3) read with Schedule 2. What they wanted to rely upon is it is rather a tax that's imposed falling under 366(28). It can never be. That's my argument.
Thank you. Thank
but
you.
I know,
Yes, Mr. Datta.
no, my only proposition was an honor. If they become the honor, and if you are, and what is mineral right? That is something embedded in the land. It is embedded in the land. You are imposing a tax on that. And only to that extent is governed by that particular limitation.
Thank you, Mr. Menon. Yes, Mr. Datta, we'll give you the last word. You can take us through to the end of the day today.
Great.
There are 2 points I wanted to highlight. One was where Mr. Kambata made a very important point, and because of time constraints, he could not do it. And it's the context of what my Lord Justice Roy asked the question, that in the Constituent Assembly debates, there was a move to shift it back to Parliament, and Dr. Ambedkar simply says, no, there is no logical reasoning. But one answer could be in the debates which came before the Joint Committee, and my Lord, my friend, House of Commons, yes. Lordship will just see the debates, give the volume. 4M, M for mother, at 54, and Lordship will just come to 56. I'm going to deal with that. And also, Lordship asked the question, this tax on minerals versus mineral rights. That also I'll clarify. Yes, Lordship. 4M. M for mother. M. Yes, where is that? Yes. This. Page 56 about the third, Mr. Spence, I think must be Sir Patrick Spence. And Lordship will just come to just above the first paragraph, last line. Page 56. Lordship will come 5-6 lines down that. It starts with the word first.
What are we reading, Mr. Datta?
No, we are reading a question where the matter was concerned by the House of Commons and earlier by a joint committee, whether the state should get an unlimited power of taxation or not. That was a short one. And there's a discussion. The other discussion is who owns the mineral rights and so on. That's not the subject matter from this bench. But what the bench said, I'll just summarize because time is short. The initial proposal in the draft was entry 54 was like the same thing. In that, at that time included oil also, but it was entry like 54. And the tax on mineral rights was not subject to any limitation. It was like tax on land and buildings, simply tax on mineral rights, taxes on mineral rights. That's all. When the matter came for discussion, Sir Craddock and Lord Percy, they said that Please see page 60. That sentence is important.
Page 60.
Yes, yes. Please come to page 56. Second, the penultimate paragraph.
I have on a former occasion.
I have on all your got it, no? I have on a former occasion. My lords have got. I have on a former occasion referred to unfortunate results which have occurred in the United States and elsewhere, where a variety of states have been allowed to deal with proprietary rights and regulations affecting the minerals of their own district. The same thing will happen in India if you have 11 states making their own laws with regard to rights of owners of minerals, whether they are vested in the crown or in private persons. It is exactly the same thing with the important question of taxation of minerals, one state imposing high taxes on mineral rights and other state imposing a different scale of taxation. This only leads to confusion and to a very uneconomic and non-commercial development of the mineral resources of a country. Therefore, I urge that as far as possible, we should take this opportunity to bring about one code of laws relating to as many minerals as possible throughout India. Now, please come to the direct on page 60.
59.
Yes.
59.
At page 59, and Lordship, this is made at 7:19 p.m. Lordship has got a Lord E. Percy. At page 59.
By written submission.
We are following.
This is, I have quoted.
We are following.
Not
Page 59.
Not Percy.
I have quoted.
Yes, I noticed Lordship has got 7:19 p.m.
Yes.
Yes, my lords have got it 7:19 p.m. Yes. I noticed that the government are not proposing to remove taxation of mineral rights from the provincial list, where it is now. How can the federal government have power to regulate the development of mines if an unlimited power to tax rights is still left in the provincial legislature? Then the Solicitor General answers, and kindly come to the second paragraph. I now come to the questions put by my honorable and learned friend, member for Ashford, Mr. Spence, and the subsequent speakers. My view certainly is that these words clearly cover the power of vesting minerals in the crown. The words would clearly entitle the Federal Assembly to make provisions as to concessions, and the words of amendments are wide enough to empower the federal legislature to cover all matters in development of mines, coordination, and so forth. Now, my lord, please come to find page 62. 60. No, with the taxation.
Yeah, this is it.
Yes. Please come to page 60. And please come to page below the Solicitor General, below Mr. Molson. Lordship has got it. Yes. Please, Mr. Molson. I'll read Mr. Molson, my lord. The learned Solicitor General keeps on referring of leaving it to the provinces. The responsibility for developing oil and coal is at present with the Government of India. What is being done under this is to transfer the primary responsibility from the center to the province, and at the same time, provided subsequently, it may be retransferred from the province to the center. The Solicitor General, I was speaking of the bill as originally drafted and comparing it with the result which will flow from this amendment. In the original bill, mines and minerals were exclusively provincial. Many matters which are now central are being transferred to the provinces, but would be out of order to go into a larger issue raised by my learned friend, member of Hastings. Lord Percy raised an obviously important point into which we shall certainly look. I can quite imagine a form of taxation which would conflict with regulation and development. In that case, I think I'm right in saying that under this scheme I have in mind at present, list 1 wins. If there is an overlapping between list 1 and list 2, list 1 wins. And this amendment was accepted. Yes. And we come to page 62. Page 61 is a speech by Sir Reginald Craddock. And just the last two portions. Page 62, my lord. Second paragraph. There is a further point. Lordship has got that. There is a further point. There is a further point that great discrimination might be caused by heavier taxation being imposed in one province than in another. If mines were being worked in one province, say by a European or a Parsi, and mines were being worked in another province by persons of some other race and status, it would be possible for a province to bring about discrimination. One province might put a heavy tax on a European mining concern, while other province might put a low tax on an Indian mining concern. There is a great necessity for maintaining control of central government over the rates of taxes and so forth, merely with a view to securing uniformity. The other royalties and income would go to the province, and the province would go in the ordinary way as they are doing now, administering those matters which they administer at present under mining rules and royalty rules, etc. Yes. If they want to alter these rules, they would require the sanction of central government. It is that way that uniformity can best be secured while allowing the provinces to have legitimate income from their mining concessions and at the same time avoiding all risk of discrimination between concession holders of different races. Lordship can say now different states. I thought that these facts derived from personal experience but usefully placed before the committee in consideration for solution. Purely wording is because of uniformity. My learned solicitor says on page 37 to 50
of my, nothing more on this era.
Yes.
1999.
Yeah. So this debate shows why tax of mineral rights was subject to a law made by Parliament to maintain uniformity, as I said, to impose financial guardrails, financial limitation. That was the proposal. But questions came from the bench. Sorry.
This is the control.
Yeah, my friend points out that this was the confusion which was sorted out eventually by the 1948 Act, saying that, look, there'll be a Mines and Mineral Act. Yes, and perhaps that could be an answer why Dr. Ambedkar felt that, look, there is no need to interfere with what was the earlier position. So you have entry 54, entry 23 and 50. Now the last point Lordship asked on taxes on minerals and mineral rights. I just put forth what I think, Lord. In para 400 of Justice Sinha's dissent in Kesoram, his Lordship rightly points out that mineral rights are embedded in the earth. Only when the minerals are won do they become minerals. Only after the mining is done, excavation is done, they become minerals. Now, on the taxing of minerals, I would just submit, Lord, because entry 84 of list 1, I'm talking of the pre-GST era, refers to goods manufactured or produced in India. Entry 84. There are judgments which say that coal is produced. Nobody can say coal is manufactured because it is in the earth. It is one, and once it is one, coal becomes produced. Then it is beneficiation takes place, purification. So coal is produced. Coal is entry 2701 of the Central Excise Tariff. Lignite is an entry. Coking coal is an entry. Petroleum is an entry. Crude oil. So maybe once the goods are produced, the taxable event is the production of the particular mineral that could be subject to Central Excise Duty. Suppose the mineral is sold. Sale of mineral will be subject to sales tax. So maybe in the context of minerals, at the mineral right stage, the taxation is on the activity of excavation, mining, whatever it is. Because once a mining lease is given, the definition of mining lease is the activity of trying to win the mine from the mine which you got a lease. So mining rights is 50. Once the coal is produced or minerals are produced, and if they are mentioned in the tariff, it will be entry 84 list 1. If the minerals are sold, it will be entry 54 list 2. This could be the architecture of the taxation powers, is my humble submission. And again, Parliament has been very careful. Under section 14 of the CST Act, coal, iron ore, many minerals are declared goods. So you can't tax more than 4%. This was 3%, it became 5%. And you can't tax at more than single point. So if it is taxed by coal, say Neyveli Lignite Corporation taxes at the point of pithead, subsequent dealers, when they sell, it can't be taxed again. So this is my submission on tax on minerals and mineral rights. That's my submission. And not the only issue of subsoil, etc. We leave it later because this is right.
Lordship, can I get 30 seconds, Your Lordship? I'm appearing for one of the interveners. Can I just get 1 minute, Your Lordship? That's all I'm praying for.
Who is the intervener you are appearing for?
Your Lordship, it is IA number 55372. It's one Ganpati Eat Udyog, and there are other 800 petitioners for which separate SLPs have been filed. We have provided the list as well. Your Lordship, this is concerning the GST.
Seth, which corporate group have you been sponsored by?
No, not at all, Your Lordship. All we are saying.
All right, thank you, Mr. Seth. We'll conclude here.
My Lord, may allow.
Sure, just 1 second.
Yes.
No, I do not know whether the present audience can answer the question that I have.
Yes, we'll try, Mara.
Because Mr. Salve should be the right person, because this House of Commons debate that you are discussing, they're giving the timing also.
Yes.
This timing, does it relate to happy hour or something?
My lord, allow.
Honestly, we have been seeing, none of us thought about this so far, Lord.
Because we are not concerned.
Lord, because Lordship reads the biography of Rufus Isaacs, Lord Reading. So he used to be in court till 5 and then go to the House of Commons. We used to be KC MP in those days. And then the Parliament would go on in the evening. So after court house, Parliament would start and go late into the afternoon.
And in the ante room of the Parliament, they used to serve.
Because if it would not have been there, Winston Churchill would definitely have introduced.
Lord, allow.
Mr. Dwivedi, so we'll start tomorrow morning.
No, really,
I need one
we are
property to circulate.
extremely
one
grateful to your Lordship for the
on
hearing.
criminal development and its effect on taxation. One page.